Welcome back. I hope everyone had a good lunch. My name is Jonathan Adler, and I'm a professor here and director of the Center for Business Law and Regulation. In this session, we are turning from questions of stakeholder theory and the obligations that corporations may have to communities and perhaps communities to corporations, and turning to look at some of the things that communities do, sometimes successfully, sometimes not so successfully, to either attract or retain corporations in their communities, whether it's trying to attract investment, employment opportunities, or other things that corporations may bring. Specifically, we're going to be looking at, and our panel will be looking at, how local communities sometimes use tax incentives and aspects of the tax code to try and attract and retain companies in those communities, and what limitations there may be on the use of such tools, and then also look at the use of eminent domain by communities and how that is used to try and both attract and retain corporate investment. And as I think all of you know, both in the state of Ohio, both of these tools are used and are often the subject of much controversy. The Kuno case, which the Supreme Court recently dealt with, and I know some of our speakers will address, came out of efforts to encourage more investment by Chrysler in the state of Ohio. And those in the Cleveland area, I think, or live in or work in the Cleveland area, are well aware of the continuing controversies over the various uses of eminent domain in the area, whether it's Lakewood's efforts to use eminent domain to encourage development, the current litigation concerning the use of eminent domain in the flats. And I think just this past week, there was a story about the Township of Euclid's efforts to use eminent domain to revitalize a shopping center along Cedar Avenue. We have four wonderful speakers to contribute to our discussion of this topic today. I'm only going to very briefly introduce all of them. Full biographies are in the packets and materials, and I would certainly refer you to those. First, to discuss questions of tax incentives, we will first have Professor Edward Zelinsky, who is the Morrison A. Trachman Professor of Law at the Benjamin Cardozo School of Law in New York, and among other things, he is the author of the book, The Origins of the Ownership Society. Also talking about the use of tax incentives will be Morgan Holcomb, who is a visiting assistant professor at the University of Minnesota School of Law, where she has what I think is an interesting distinction of teaching and writing in both the areas of tax law and agricultural law, which are not two subjects that I at least think of always necessarily going together. But there are a lot of us that teach courses that might not go together. Next, Ilya Somin, assistant professor of law at George Mason University School of Law, co-editor of the Supreme Court Economic Review, and in at least one article, my co-author, but don't hold that against him. He will be turning to questions of eminent domain, and then also to talk about eminent domain, we're pleased to have Stephen Kaufman, who is a partner in the litigation practice at Thompson, Hine, and also an adjunct professor here at KACE, who will also be talking about the use of eminent domain. So with no further ado, I will turn the podium over to Professor Zelinsky.
Well, thank you for that very gracious introduction, and in particular for mentioning my new book, which I'm going to shamelessly promote at the end of these comments. When the dean called and asked me to come here today, first of all, he could walk at that point. Second of all, he was able to invoke a variety of historic connections. We were in law school together. We clerked for the same federal judge. And then he said to me, and everyone knows that the weather in Cleveland is balmy 79 in January. I grew up in Nebraska, knew that wasn't true, but I chose to come anyway. In fact, this is a particularly useful and helpful invitation because it has forced me to bring to a conclusion a variety of thoughts about things I've been thinking about at some level for the last 5 years, at some level for most of my life. And therefore, my comments will be, I think, both very personal and, at the bottom line, quite pessimistic. I'm going to talk about tax incentives, and I have a sense that I have lived with this issue and lived with this problem for most of what I euphemistically used to call my adult life. It's no longer such a euphemism. I was originally confronted by this issue when I was in law school, when I was elected to the New Haven Board of Aldermen as a second-year law student. And I dealt with the issue for another 18 years, both as a member of New Haven's City Council and then as a mayoral appointee. And I have seen the proliferation of these tax incentives from a first-hand point of view. I'm that most dangerous of all law professors, a law professor with a little practical experience. And the issues that they pose are quite real. The pressures under which municipal officials act are quite real. And the short-sightedness of municipal officials is quite real, and I know that because I, in fact, was such a municipal official. I'm quite sure that when I meet my maker, on the list, I think it'll be the B list of my sins, will be any number of tax incentives which I helped to grant to various corporations and businesses. The A list of sins is more interesting, which is why I'm not going to discuss it publicly. But definitely on the B list of sins will be the tax incentives which a community like New Haven granted with very little discipline throughout my 20 years as an official. And the background was very similar to the background which we have here in Ohio today. The process of deindustrialization, as it's euphemistically called, the decline of manufacturing industries, places tremendous pressure on elected officials to attract industry and to attract industry of very specific types. The people who work in factories, Olin Winchester was a major employer in New Haven when I was young. When they moved their activity overseas, that created tremendous pressure at every level of municipal government. And when an individual is being elected or reelected to office every 2 or 4 years, indeed the pressure to place on them in terms of tax incentives is very real. So at one level, this is an issue that I have lived with on a very personal level for most of my adult life. Then, as we were just told, there was a major litigation that came out of Ohio, the Cuno litigation, and I was one of the commentators. As you can see from the material you have, I'm someone who thought that as a doctrinal matter, the court should not intervene in Cuno. And that is based on the fact that I don't believe there's a coherent dormant commerce clause in general, a dormant commerce clause notion of discrimination. And I think it's particularly incoherent in the context of tax incentives. And I'll discuss that in a moment. But critical issue that I drew then, and that this has given me an opportunity to think about, is that while I believe the courts should not intervene under the Dormant Commerce Clause to discipline tax incentives, that doesn't mean tax incentives are a good thing. And here I would identify, both in the scholarly literature and I think in political discourse, 3 different approaches to tax incentives. There is first, of course, the notion that all tax incentives, all tax competition is a good thing. And in the academic community, I would say there are 2 subdivisions of that approach. One is, of course, what, for lack of a better term, I would call Leviathan conservatism, the notion that since government is a monopoly, you want, whenever you can, to deny it revenue. And that certainly is a point of view that is held by a great many individuals. It's also a point of view that makes discussion very easy, because whatever governments can do to give away their revenue base becomes a good thing under those circumstances. A subvariant of the all incentives and all tax competition is good position. A subvariant is a more sophisticated argument that says that essentially efficiency norms are leading communities and businesses to contract for efficient deals. And the best articulation of that theory, I believe, is Professor Gillette's arguments, where he has developed some very sophisticated arguments indicating that there will be a tendency in the incentive process for communities and businesses essentially to deal effectively. It's a rational market theory of incentives. And from that perspective, there is not a problem. There is at the other extreme, and of course what I'm doing is going to paint myself as the middle between these two extremes. The other extreme is the position that says tax competition between jurisdictions is a bad thing. And I think it's fair to say that the lawyer, academic lawyer, Peter Enrich, who represented the Cuno plaintiffs, as well as others, are basic adherents of that position. Now, the people who adhere to that position, particularly in the academic community, are always very careful to say that they don't mean there should not be competition between communities for general tax rates. They're always very careful to caveat that out. But the bottom line is that many of the individuals, and certainly the motivation behind the Cuno litigation, was based on a notion that the interjurisdictional competition is a bad thing. Now, fortunately, in the middle are the mushy moderates like myself, who believe that targeted tax incentives of the sort that I participated in when I was young, targeted tax incentives tend to be a bad thing, but that generalized tax competition is a good thing. The notion that generalized tax competition is a good thing is based on the theory that we should have and we do encourage competition between jurisdictions, and that's a good thing. Some people call that theory the theory of federalism. Others tend to call it a theory of Tibu economics, after the gentleman who is generally considered to have made the seminal statement in the 1950s on this subject. And the basic notion is that metropolitan governments, which appear to be divided and fragmented, competitions between states, these are really good things. That competition in terms of taxes disciplines political decision makers who might not otherwise be concerned about taxes if they were in more monopoly situations geographically, and that the sorting effect where individuals, firms, and families can sort themselves by jurisdiction is a good thing. People can go where the package of public services and the appropriate tax rate makes sense. Now, one of the reasons I'm a mushy moderate is because my practical experience and my theoretical experience suggests to me that both stories are true. That is, tax competition of a general nature is a good thing. It does discipline elected officials who often need the discipline. The sorting effect is a good thing. But it is often the case that targeted tax incentives are bad. And they're bad for a number of reasons. First of all are the terrible information asymmetries between public officials and firms. The firms know whether they have really decided to locate or not, and they're never disclosing that to the elected officials with whom they're negotiating. That symmetry invariably suggests that the elected officials are bargaining with one hand behind the back when they are engaged in these negotiations, and that is because they ultimately can't afford to lose the negotiations. They're running for re-election in a year or 2 years or 3 years, and in fact, they don't know whether or not the firm with which they are negotiating is telling the truth when they say, we will go elsewhere if you don't give to us. And I know those pressures are very real, having been under them for the better part of 20 years. So the problem is that in these situations, when you have targeted tax incentives, whether they constitute particular package deals between municipalities and states, or whether they are embodied in legislation, the businesses have a better handle on those negotiations. They invariably have a stronger negotiating position than do the municipal or state officials. And the net result is that there is a tremendous technical inefficiency in targeted subsidies. It is inevitable that municipal officials will wind up giving tax incentives to locate firms that would have located anywhere and anyway, and that therefore incentives are invariably granted where they were not necessary. And the net result is, over time, communities and states that engage in targeted tax competition find themselves on a very unpleasant treadmill. This is what happened during my term, my 20 years in New Haven, but it's not unique. What happens is you wind up with newer, more mobile firms paying less tax than older, sedentary firms. You find yourself in a community where the tax rate is effectively very different for different people, different firms, depending on when they negotiated, how they negotiated, what their bargaining position was, whether they could bargain at all. And that treadmill that municipal officials find themselves on is very difficult to get off. After all, if firm A has been recruited with a package of incentives, as was involved in the Cuno case, it's very hard to deny firm B. And so you wind up in communities which use these incentives with tremendous efficiency and fairness problems. The fairness problem is two adjacent taxpayers, essentially similarly located, paying radically different taxes based on their bargaining power with respect to the municipality. And that's a highly inefficient situation because, among other things, it results in a higher tax rate on the unfavored taxpayers. Higher taxes then cause deadweight loss. Deadweight loss then makes it more difficult for industry to come in, and that's the treadmill that many of these communities find themselves on. So what is the solution? Well, this is where I'm afraid I get increasingly pessimistic because I don't have a good solution, and it's not that I haven't been searching for one. As I indicated, the Cuno plaintiffs and others who have started similar litigation believe that the solution is the Dormant Commerce Clause of the federal Constitution. I believe that it is not, for doctrinal reasons. I don't think it's a coherent notion. You have, and you're going to hear tomorrow from my colleague and one of the other Dormant Commerce Clause mavens, Professor Denning. All of us have different views on it, but I ultimately believe that the federal courts are not going to salvage, and the state courts using the Dormant Commerce Clause are not and should not be the fora for these debates. You then respond, well, how do municipal officials get off this treadmill? The answer is it's very difficult because the problems that exist here, the informational imbalance between localities, states, and the firms, and the collective action problems. If the mayor of community X doesn't offer an incentive, the mayor of community Y next door will. Makes it very difficult for officials to self-discipline in these situations. It's a very difficult, very difficult situation in which they find themselves. And so the more obvious thought is, well, this is an area where perhaps it's appropriate for there to be federal legislation. After all, the Commerce Clause is ultimately Congress's to enforce. Why shouldn't the Congress put an end to destructive tax competition while allowing healthier tax competition to continue? In the short run, I think it's very clear that Congress has no interest in adopting legislation of this sort. I've actually testified in front of two of the House subcommittees that would have jurisdiction in this area, and it's very clear to me that there is no consensus and no particular interest in Congress for addressing this issue. There was one hearing right after, while the Cuno decision had been decided by the Sixth Circuit, cert was then pending. It's very clear to me that Congress, as a reactive body, like any other legislative body — I was a reactive legislator also in my years on a municipal city council — that a reactive body is just that. It's going to respond to pressures and consensus, and the reality is there is no particular consensus right now for effective legislation. I'm also concerned, and this is really what makes me a pessimist, that even if Congress said it wanted to elect legislation, that there's really a workable solution. The distinction of the mushy moderates such as myself between targeted tax subsidies and generalized tax competition is very easy to state in theory. I find it very difficult to reduce to effective legislative terms. To cite one of the distinguished sons of the state of Ohio, it's true, I know it when I see it. I know targeted tax subsidies when I see them, but that's not a meaningful legal standard that should be adopted legislatively. And then I come to a final issue, and that is, why isn't there more of a political backlash in many communities to these incentives than you would predict? And I think there are a number of reasons. I think, first of all, I think there truly are framing effects, that it's true that average taxpayers often don't understand the economic implications of tax incentives and therefore don't understand the implications of what it has, those incentives have for their own tax bills. I think it's also, again, because the electorate, like the politicians who are responding to that electorate, tend to be very short-sighted. There was a discussion this morning about short-termism. Are shareholders oriented towards the short term? I'm not going to get into that debate, but I certainly will tell you that voters tend to be very short-term oriented, having put my life in front of voters 8 times. A visionary, I find, in local government is often the person who's thinking about the day after tomorrow. So the political incentives, I think are not very real. But then you come to one other important consideration that I think has to be put on the table, and that is, who owns these corporations? And there's one argument that says, well, rich people own corporations. But when you look at the ownership of publicly traded corporations, increasingly, publicly traded corporations are owned by middle class and upper middle class voters. The people who hold those shares in their IRAs, their 401k accounts, their kids' 529 accounts. This, by the way, is the moment for my shameless pitch for my book, which in fact discusses this revolution and this evolution, and which I think has not been fully factored into our thinking about corporations and tax incentives. Many years ago, Peter Drucker talked about the growth of pension fund socialism. He was a very, very perceptive man. He was far more perceptive than he realized. When he made those observations, the traditional defined benefit plan was still the dominant mode of pension plans. And therefore, to say that corporations were owned by workers and pension holders was true, but it also wasn't true, because what they had was a claim for annual income against the pension plan, ultimately guaranteed for the corporation. So their ownership of these corporations was at best mediated through the plan, through the corporations. With the tremendous shift of ownership to 401k, individual retirement accounts, the growth of 529 accounts for individual accounts, my guess is we're going to see over the next 10 years the similar growth of health accounts. The ownership of the account owner, the connection of the account owner to what is in his or her account, is far more direct, far more apparent. And I think, by the way, George Danta, another friend from the past, referred to the dog that didn't bark. He's absolutely right. There are lots of dogs that haven't barked. Another dog that didn't bark that I would suggest to you is the discussion that occurred in the new Democratic Congress, let's go after the oil companies. Why didn't they go after the oil companies? Well, there are a number of reasons they didn't go after the oil companies, but one of the reasons they didn't go after the oil companies is because much of the stock of the oil companies is owned by Democratic voters in their IRAs and their 401k accounts. And therefore, to talk about corporations, them and us, is not always very helpful in these contexts. Talk about corporation management is very different, but to talk about the beneficial ownership of these corporations is very different. So the bottom line is that on the subject of tax incentives, I confess to you I come away something of an agnostic. I do believe targeted tax incentives are, as the critics suggest, bad. I think generalized tax competition is good. I think that the courts are not the place, doctrinally or otherwise, that can help resolve these issues. I'm skeptical, at least for the short run, that Congress is going to intervene. And I think officials are on something of a treadmill. And I don't see an easy way for them to get off. If between now and when I'm obligated to turn these remarks in for formal publication, I come up with a solution, I promise I will tell you. But since I've been searching for it for 25 years, I'm not optimistic.
Well, thanks very much, Adam, and the staff and board of the Law Review, as well as the great technical and administrative staff that you have. I'm really pleased to be here, and this is a great symposium. I have two modest goals today. The first is to make my PowerPoint slides work. The second is to explain what's going on in the litigation landscape following the Kuno decision. Ed is, I think, rightfully skeptical that the courts are a great place for these problems to be resolved, but that doesn't mean that plaintiffs aren't going to keep bringing these cases. So I want to start out just with some basics to make sure that everyone's on the same page when we're talking about these tax incentives. The title of this symposium is Corporations and Their Communities, and most communities want more corporations to call their community home. And one way that they do that, communities do that, is to enact these sorts of tax incentive programs. These usually work by reducing a particular tax burden, a property tax burden, or a sales or a franchise tax burden, in exchange for the corporation performing some economic activity in that community. For example, my adopted home state, Minnesota, has a program called JobZ, or Jobs, in which businesses that locate in certain economically depressed areas, I think we should change it from depressed, I think that's bad PR. We're going to call them economically challenged areas of the state, get some tax incentives. As Ed pointed out, these incentive schemes are not new. And there is a sustained and rigorous debate about whether or not they work, either sort of work writ large, like does this increase the total pool of economic activity that's going on, or even work sort of locally. Is this activity that would have happened in this locality anyway? Are we sort of giving away the store? And there is also maybe a somewhat newer debate, I would suggest, about whether or not these incentives are constitutional. And that debate really hit a high watermark in 1996 when Peter Enrich, who teaches at Northeastern Law School and was the plaintiff's attorney in Kuno, published an article in the Harvard Law Review setting forth his thesis that these incentives, at least the way some of them are promulgated, violate the Dormant Commerce Clause. So today I'll talk about the litigation. First I'll talk about Kuno, and then I'll talk about the litigation that I think Peter's article has generated. So, but before I get there, let me start with, oh no, I skipped a slide. Okay, we'll start with this. See, I knew my goals. I should have been a little bit more modest with my goals. Okay, so the sort of the constitutional nitty-gritty that I think we, again, to get us on the same page. So we start, of course, with the Commerce Clause, which is the affirmative grant of power in the Constitution to Congress to regulate commerce. There has been some good scholarship talking about the role that taxes played in getting the Commerce Clause into the Constitution in the first place. There's also been an important role for taxes in the Dormant Commerce Clause doctrine. So the Dormant Commerce Clause, of course, is the idea that even if Congress doesn't legislate in a particular area, states cannot regulate or impair the flow of interstate commerce. At least they can't regulate it or impair it too much. In the world of state taxes, the test that applies when a state tax is challenged as violating the Dormant Commerce Clause is called the Complete Auto Transit Test. It is a four-pronged test, only one of which seems to matter for these state tax incentive schemes, and that is the discrimination prong, which is the third prong. A tax should not discriminate against interstate commerce. And finally, another constitutional fundamental that's going to matter, and in fact mattered a lot to Peter Enrich and Charlotte Kuno, is the notion of taxpayer standing. So federal litigants have to have both constitutional standing and sort of prudential standing requirements. So not only do you have to show injury and causation and redressability, but the court also isn't going to entertain what it calls generalized grievances. And this generalized grievance notion has generally kept, with one sort of very narrow exception, has generally kept federal taxpayers out of federal court. It has also generally kept state taxpayers out of federal court. Again, there is a little bit of wiggle room there, but generally speaking, state taxpayers, their interest in what's going on with their state tax dollars is simply too attenuated. It's shared with too many others. It's not going to be the type of concern that the federal courts are going to address. There does still appear to be municipal taxpayer standing, though. Okay, so with this background in mind, let's turn to the case that might have proved Peter Enrich right, and that is the case that started just a few miles from here, the Kuno v. Daimler Chrysler case. Okay, hold on. Before I get there, though, it's not just academics and politicians who are concerned about these economically challenged areas. In fact, Ohio's own group, the Pretenders, has also been concerned about this. Let's just see what they have to say about it real quickly.
I went back to Ohio, but my city was gone. There was no train station, there was no downtown.
Okay, so I'm glad that worked because I was going to sing it otherwise and nobody would have appreciated that. So a later line in this sort of protest song, I think, is this happened by because we had this government that had no pride, and I think that's maybe partly what legislators and policymakers are having to deal with. We've got demands from places as diverse as corporations to the Pretenders' lead singer saying, do something about these economically depressed areas. And so Ohio did, and I actually don't know when that song, I should have found out when that song was written. Maybe the Ohio legislators were responding directly to it, I doubt it. But Ohio had a two-part tax incentive scheme. Daimler Chrysler was going to expand its Jeep factory. It could do it in Ohio, or it could have chosen to do it anywhere, but I think Michigan was another prime contender. And as an incentive to get Daimler Chrysler to do the expansion in Ohio, Daimler Chrysler was permitted to get two tax exemptions. One was a property tax exemption, and another a franchise tax exemption. When we're talking about these sorts of exemptions, there's been this carrot or stick analogy that I think Walter Hellerstein came up with, and that's the idea that carrots are going to be okay. So if what you say is, come to our state and do some new economic activity, and we won't tax you on it, that's okay, that's a carrot. A stick, though, is understood as, do this activity in our state, and we'll reduce your pre-existing tax burden. Do it in another state, and we won't. We're going to subject you to the as much tax as we possibly can. So that is a tricky distinction, I think, to keep straight in actual practice. But it makes it's sort of something to at least start getting your head around these distinctions. So the case was brought actually in Ohio State Court. The defendants removed to the federal district court. And at the federal district court level, the plaintiffs, including Peter Enrich, said, well, we're going to move to remand. We're not sure that we have standing as taxpayers. We probably do, but we're not sure that we do. The district court said, no, your standing is fine, at least as municipal taxpayers, and the plaintiffs lost in the district court. It then went to on appeal to the Sixth Circuit, and nobody talked about standing there. And the Sixth Circuit issued sort of a split decision. They said this property tax exemption, this sort of carrot, is okay. That's fine. The franchise tax exemption, though, is not okay, and in fact violates the Dormant Commerce Clause. So the split decision is sort of, I guess, like kissing your sister. Nobody liked it, so the parties cross-appealed, and the Supreme Court granted cert to the franchise tax exemption. The Supreme Court then, in a day which is probably not Peter Enrich's, the plaintiff's attorney's best day, ordered briefing on standing. And found that indeed the plaintiffs lacked standing vacated the Sixth Circuit judgment and remanded the case to a lower court for dismissal of the challenges. So the case went back to the Sixth Circuit for dismissal. I spoke briefly with Peter Enrich last week, the plaintiff's attorney last week, and I said, well, are you back in Ohio State Court? Did you get remanded? And he said, no. By the time the case had been procedurally ready to go back to state court, the state tax incentive scheme here had shifted dramatically. And the incentives the particular incentives at issue in the Kuno case were about a year from timing out. And so the plaintiffs very reluctantly, I think, said, given the litigation strategy that we predict Daimler Chrysler would do, which is basically delay and then move to dismiss on mootness, we're not going to pursue this. Also in my discussion with Peter, he indicated that he's not going to give up the fight. He is, I think, a firm believer in Ed's sort of second group, which is people who believe that tax incentives are very bad and unconstitutional, and he is looking for additional plaintiffs. The type of plaintiff he's looking for, he talked about in a recent symposium that he did at Buffalo Law School, which is very similar to this one, talking about corporations. And he said he's looking for 3 attributes for a good plaintiff. He's looking for a good target. So he's looking for a statute, I think, that has this sort of stick. We are going to subject you to the maximum possible taxes we can unless you bring some activity here versus another state. He's also, of course, looking for somebody with good standing. I think after you get all the way to the Supreme Court and get kicked on standing, you are very careful about that one in your next case. And finally, he indicated what was a critical factor for him, and that is he's looking for a place where he can put forth a grassroots organizing effort. And that, I think, is something that Ed touched on a little bit. Why isn't there more of a public outcry about this? And Peter expressed some regret, at least on at the Buffalo Symposium, that there was an opportunity for public awareness and public education that somehow got missed in the Kuno case. And so I think he's probably looking to remedy that with his next group of plaintiffs. So just because Peter doesn't have a plaintiff right now, though, doesn't mean that there isn't litigation going on in the states. And right now there's litigation ongoing that I know of, at least in 2 states, and some recently wrapped up litigation in Wisconsin. I'll talk primarily about Minnesota and North Carolina today, and I might touch on Wisconsin if anybody cares. Okay, so Minnesota, spoken like a true Minnesotan, right? Wisconsin is. So Minnesota, as I said, has the Jobs Z, or the Jobs program. And I want to emphasize, I put this blurb on from the annual report because I want to emphasize sort of the I think, true belief in these types of incentive programs that sort of tax incentive boosters have. So the goal of the Jobs program is to attract new and expanding business, create thousands of good jobs, contribute to robust economic health, and restore a sense of hope for the future. I think that Governor Pawlenty, Minnesota's Republican governor who first enacted the Jobs program, really believes that these tax incentives are going to restore hope to parts of outstate Minnesota that are right now quite economically challenged and depressed. But of course, there are those on the other side, and generally these cases involve at least one plaintiff who is sort of ideologically opposed to the incentives. And that's the case in Minnesota. There are 2 lawsuits, Olson, which is, I think, finished, and a new case called Interstate Motor Trucks. Both of these were brought by, or at least in one of the plaintiff's attorneys was a guy named John James. He was the former director of Minnesota's the commissioner of the Department of Revenue. And Olson was the former lieutenant governor. So we had sort of a very political setup for this lawsuit. Olson raised primarily Minnesota constitutional claims, but did at least raise sort of an Enrich-style Dormant Commerce Clause claim, federal Dormant Commerce Clause claim. The Olson case was dismissed on standing by the Ramsey County District Court, which is Ramsey County is where St. Paul, the capital of the state, is. And just last month, the Minnesota Court of Appeals, in an unpublished decision, said, yeah, you're right, District Court, there is no taxpayer standing here, using Minnesota taxpayer standing. So they didn't reach any of the constitutional claims, didn't reach the Dormant Commerce Clause claim. Interstate Motor Trucks, I think, in sort of an interesting twist, asserts some violations of the Minnesota Constitution, but does not raise the Dormant Commerce Clause claim, the sort of Enrich, I'm calling it the Enrich-style Dormant Commerce Clause claim. And the Interstate Motor Trucks plaintiffs are seeking a declaration of constitutional invalidity. They're seeking a declaration that the jobs contracts are void, and they're also alternatively seeking tax refunds for the plaintiffs. So given what happened in Olson, it's not surprising that the state has asserted an affirmative defense that the plaintiffs have no standing. Now, there are some differences in the plaintiffs here. In the Olson case, the plaintiffs were simply taxpayers. They didn't allege anyway in their complaint that they were competitors of businesses that were receiving these Job Z benefits. In contrast, in the current case, the taxpayers are alleging, look, we are in this job opportunity building zone. We are direct competitors of these other guys who are getting it, and we're not getting it. So they're trying to establish a direct injury to themselves, and I think avoid this problem of taxpayer standing, the taxpayer standing jurisprudence. And I don't blame them for trying to avoid the taxpayer standing jurisprudence because it's not very clear. Minnesota's taxpayer standing jurisprudence is, I think, it's fair to say, a little messy. It's unclear what the Supreme Court would do. There haven't been, the Minnesota Supreme Court, there haven't been very many Minnesota Supreme Court opinions on it. And the Court of Appeals opinions are hard. It's hard to figure out exactly what's going on. There's language in the opinions to indicate that, well, Minnesota taxpayer standing is much broader than federal taxpayer standing. But then the Minnesota court cites the United States Supreme Court federal taxpayer cases when it dismisses on standing. So there's some confusion there. There's also a doctrine in Minnesota that indicates that, well, if you can show an unlawful disbursement of public money or an illegal expenditure, you can maintain your suit under taxpayer standing doctrine. But it's very unclear what an illegal expenditure is. Does it have to be sort of a contract that was procured by fraud? That was a case that showed an illegal expenditure. Or can it be just something that's, if we're talking about an unconstitutional program, state program, that's using state funds to, for example, pay the people who write up the jobs contracts, is that enough? There's no clear answers in the, at least in the Minnesota taxpayer standing jurisprudence. So I think that'll be the first hurdle that the plaintiffs will have to face. And I spoke briefly with the, at least one of the attorneys for the, in the Minnesota cases, and he suggested that, well, this case is going to turn out differently because we have better plaintiffs, so we're not going to get kicked on standing. And he also talked about a shift in the political winds. I said, well, how'd you find these plaintiffs? You guys are sort of players. Why didn't you find them the first time? And he said, well, when we first filed suit, Governor Pawlenty, Minnesota's governor, was very popular. And the economy seemed to be okay, and it sort of felt like something was working. And so people sort of were holding back. He said, now that's not the case. Minnesota's economy is not doing that well, and maybe no state's economy is. And the governor has lost some, I suppose he's used up some of his political capital. So all of a sudden we have some plaintiffs who maybe wouldn't have stepped forward initially, who are willing to step forward now. And it'll be interesting to see if that impacts the sort of overall political attitude towards programs like Job Z. Okay, so that's Minnesota. I also want to talk about North Carolina. And again, we have two lawsuits, one of which is recently wrapped up and one of which is ongoing. So the first one deals with Dell. And this is a case called Blinson versus North Carolina, which was decided by the North Carolina Court of Appeals in October. As far as I know, there's no appeal from this case to the North Carolina Supreme Court. And I should mention that the time to petition for review for the Olson plaintiffs has expired, and they did not file a petition for review to the Minnesota Supreme Court. So in the Dell case, what was going on was North Carolina passed a tax incentive plan that didn't specifically mention Dell, but it was pretty clear that that's who they were getting at. A group of plaintiffs, including Robert Orr, who's a former North Carolina Supreme Court justice, truly believes that these incentives are a bad idea, bad economic policy, and violate at least the North Carolina Constitution. And so Robert Orr and his group, the North Carolina Institute for Constitutional Law, filed suit in North Carolina to challenge these incentives. In the Blinson suit, some North Carolina claims were raised, as well as, again, this enriched-style Dormant Commerce Clause question. Blinson, again, could have been an opportunity for the North Carolina Supreme Court to start sort of pulling back on this idea that, well, these tax incentives can be a public purpose, serve a public purpose. And I think there was some belief that maybe that was going to happen because the Kilo case had happened sort of in between. So while Blinson was pending, we had Kudo and we had Kilo, but that didn't happen. That didn't happen because the North Carolina Court of Appeals was bound by a previous North Carolina Supreme Court opinion that said, no, this is a public purpose. The taxpayer standing, it's okay, I'm going to go back and just talk real quickly about taxpayer standing. The trial court had dismissed everything on standing. The appellate court said, well, there's some standing. There's standing at least for the North Carolina claims, but there's no standing for the Dormant Commerce Clause claim. And the appellate court found that for the claims that there was standing, these are constitutional because they felt they were bound by this previous case. And it was a pretty recent North Carolina Court of Appeals case called Meriday in 1996. Now, interestingly, Robert Orr, who's the plaintiff's attorney in Blinson and the plaintiff's attorney in the Google case, which I'll mention soon, was the dissenting justice in this 1996 case. So it all feels very closely related anyway. If I criticize the Minnesota taxpayer standing, I think it's only fair for me to be as critical of the North Carolina taxpayer standing. I don't think that North Carolina taxpayer standing cases are any more clear. And I'll just pick specifically on the North Carolina Court of Appeals dismissal or holding that there was no standing for the Dormant Commerce Clause decision. While paying lip service to the idea that, well, North Carolina taxpayer standing is broader than federal taxpayer standing, and in fact, they're saying in North Carolina you can bring a taxpayer standing suit. The Court of Appeals said, well, there's no standing to pursue a dormant commerce claim here because the taxpayers wouldn't have had standing in federal court to pursue a Dormant Commerce Clause claim. And that's the point when I was reading the case where I said, huh? And I had to read it again to make sure that was right. I mean, it might be that in North Carolina, the North Carolina courts say when there is a constitutional claim, we are going to have a different taxpayer standing jurisprudence than our sort of regular taxpayer standing jurisprudence. But it's not the case that just because you can't bring a federal constitutional challenge in federal court, you can't bring that same federal constitutional challenge in state court. So I think there's room for some improvement in the North Carolina taxpayer standing jurisprudence. So the Blinson case is, I think, gone. It doesn't appear that there's going to be an appeal. But there is still an ongoing case. Former Justice Robert Orr is not to be deterred, and he has brought another case, same plaintiffs lawyers, the North Carolina Institute for Constitutional Law, and they're challenging this tax incentive scheme that was directed toward Google. Google's not actually mentioned in the legislation, but it's any eligible internet data center. And I think Google was the only one they had in mind, the only one they were negotiating with. And again, I think notable, there apparently is no Peter Enrich-style Dormant Commerce Clause claim. Instead, they're relying on state constitutional claims, including the couple that I've got listed here. And again, I think there's some concern about standing. And in this case, unlike the Minnesota plaintiffs who found at least sort of a different way to attack the standing problem, in the Google case, it appears that the plaintiffs are generally just basing their standing on sort of the general taxpayer standing jurisprudence of North Carolina. So it'll be interesting to see if that gives the North Carolina courts an opportunity to clarify any of this taxpayer standing stuff. They clearly won't be able to address the Dormant Commerce Clause problem that I pointed out in the Blinson case because there's no Dormant Commerce Clause claim here. So a couple of common themes from at least the Minnesota and North Carolina litigation is that standing's going to matter. Taxpayer standing standing itself, I think, is tricky. Taxpayer standing, I think, is even trickier, and it's something that the courts, I think we see state courts struggling with. There also appears to be this movement away from raising the Dormant Commerce Clause claim. I don't know why that is. None of the attorneys that I spoke with addressed that. My speculation, and it's sort of fun to speculate, so I will, maybe they don't want to be in federal court, they want to stay in state court, and so they're preventing any sort of successful removal action by not bringing a federal claim. I'm not sure. There's a turn to state constitutional issues. And maybe we're also seeing a shift in a political tides. Maybe we're seeing less sympathy for these types of incentives, and maybe that will play out in litigation as well. Just real quickly, I want to mention or amplify a bit what Ed said. I don't anticipate that Congress will do anything. There was the Economic Development Act of 2005 proposed, pretty much the same language in 2006, pretty much the same language in 2007. Lots of sponsors, but there doesn't appear to be a lot of attention to the issue. And I'd be extraordinarily surprised now, this year, given the presidential election and really the focus on other issues, whether or not anything's going to happen. And I also think once Kuno got kicked on standing, the wind sort of came out of those sails. So I don't think that's going to go very far. And I also just want to mention briefly that, well, if you can't attack the problem head on, so if taxpayer standing is going to keep the courts from addressing these problems, maybe there's another way to do it. And as I was researching this, I saw that the Kentucky Attorney General was sued by Kentucky's Cabinet for Economic Development so that Kentucky's AG would stop sniffing around to see if companies were complying with their incentive package terms. So, and I don't know what happened. There was clearly some sort of settlement or some sort of agreement because this happened a while ago and I couldn't find anything else on it. So maybe that's sort of a sideways way to get at what we're not able to get, what critics of tax incentives are not able to get at directly. Maybe we can hold companies' feet to the fire a bit more to try and address these, what some people perceive as big problems with tax incentives. I think I'll stop there, and I'm happy to answer any questions about any of the state litigation. I think at the end. Okay, thanks.
Can you shut this down?
Yeah, I'm trying to.
Maybe we can just go like this.
It won't. I'll try. Malfunction F8. I'm sitting there on the button. That would explain it. Thanks.
Can I go like this?
Just wait one more.
Thanks. I'm going to be talking today about the use of eminent domain for purposes of economic development. Obviously, the issue of economic development takings has become extremely controversial since the Supreme Court said that condemnations for economic development were permissible under the federal Constitution in a 2005 Kelo decision. So I'm grateful to the Law Review for organizing this symposium and inviting me. I'd also like to express my gratitude to the Supreme Court for deciding Kelo, because even though I think they got it wrong, they certainly gave a great career boost to people like myself who write about these issues, and I've now generated some 4 or 5 articles as a result of this, and I intend to continue to shamelessly milk this puppy at least until I get tenure, and then I can go fishing a lot like Jonathan does now since he has gotten tenure. But in the meantime, I'm going to continue to talk and write about Kelo and economic development takings, and in fact, in today's presentation, I draw on 2 of my articles. One, an article about Kelo and economic development takings generally, published in a Supreme Court Economic Review last summer. The other, a paper that I'm working on, which discusses the extensive legislation that has been enacted in response to Kelo, both at the state and federal levels. That's available on my SSRN website and also on my personal website. So that's my next big project in this area. So in this presentation, I'm not going to go into the details of the Kelo litigation or why I think Kelo was wrongly decided, although I do cover that extensively in the Supreme Court Economic Review piece. Instead, I'm going to talk first about why I think economic development condemnations are generally undesirable and harmful, not just from a standpoint of the damage that they do to property owners or the unfairness, but even from the standpoint of promoting long-term economic development into communities that practice these kinds of policies. Then I'll talk briefly about some of the alternative proposals that have been made for solving these problems that fall short of a categorical ban on economic development takings, and I'm going to suggest that those proposals, while not without merit, are actually not as good as a categorical ban would be. And finally, I'll talk briefly about the post-Kelo reform legislation that has now been passed in some 42 states as well as the federal government, and I'll talk a bit about the strengths and weaknesses of that legislation and why, in my view, so much of it has actually fallen short of actually accomplishing anything. So to first start out on the question of economic development takings, what is an economic development condemnation? Quite simply, it's a situation where the government condemns property belonging to one person or group and transfers it to another private entity solely on the hope or expectation that the new owner will produce more economic development in the community than the old one did. So there's not a traditional public use characterized by government ownership, such as a road or a bridge. Neither is there some sort of common carrier that the public has a legal right of access to. Rather, there is just the hope or the expectation that the new owner might contribute more to economic development. Now, my general perspective on these sorts of takings is that in reality, they are not actually driven by any kind of rational process of determining which areas can be used to promote economic development in this way, but rather primarily by a process in which local governments use this kind of taking to transfer property from the politically weak to the relatively more politically powerful, often to corporations, but sometimes to other kinds of private entities as well. And it therefore, these transfers from the weak to the powerful are likely to do much more to harm local economies than to benefit them, as well as obviously creating injustices and unfairnesses towards the property owners who are unfortunate enough to be victimized by them. Now, of course, you can say, well, virtually any kind of condemnation, there is this risk that it will in reality be a matter of interest group politics rather than general public benefit. But I would say that there are several reasons why with economic development takings, the risk is greater than with most, if not all, other types of condemnations. The first such reason is the incredible scope of the economic development rationale. As the Michigan Supreme Court pointed out a couple years ago in its Hathcock decision, which banned economic development takings in that state, virtually any condemnation that transfers property to a private business could potentially be justified by the economic development rationale. After all, pretty much any business, whether it's a corporation or not, could say, well, if you give us some more land, particularly at discount prices, as usually happens, we can use that to make some more profits for ourselves and thereby, in some sense, contribute to economic development. So the potential demand for these kinds of takings from powerful interest groups is quite high. Now, this high demand might not be such a problem if the supply side on the political market was more effectively monitored by voters. If voters had the ability to, say, punish politicians who approve harmful condemnations, then maybe these sorts of issues wouldn't be a problem and only the quote-unquote beneficial condemnations would go forward. In reality, however, there are several reasons why voters have great difficulty effectively monitoring these kinds of condemnations, and indeed why in most cases I think effective monitoring is probably close to impossible. One is that unlike with a road or a bridge or other more conventional takings, it's extremely difficult for voters to determine whether the economic development condemnation is paid off or not. With a road or a bridge, although there are often problems, you can at least tangibly see the results. So you see the bridge and you see how it's a little bit easier to get through your rush hour traffic or whatever. With an economic development condemnation, it's going to take many years before it becomes clear whether more development has been produced than existed beforehand. And even then, even after you see the results many years later, it's still very difficult to tell whether a development produced as a result of a condemnation was actually greater than whatever economic growth would have occurred if you had just left the pre-existing owners alone and let them continue with their own projects. Even experts have trouble evaluating this, and certainly ordinary voters stand relatively little chance. This is part of a much larger problem of political ignorance among voters about public policy. In some of my other work, I have compiled extensive data showing that most voters know very little even about the basics of public policy and government, much less about relatively complex projects of this type. And indeed, as I and other scholars have pointed out, it's actually rational for the average citizen to be ignorant about politics, because if your only incentive to learn about politics is to become a better voter and vote for quote-unquote the right candidate, that turns out to not be much of an incentive at all, because the chance that your vote will actually be decisive in an election is infinitesimally small, usually one in, at best, several 100,000, or even in the case of a presidential election, one in about 100 million. And indeed, most voters do in fact behave rationally and acquire very little political knowledge. Now, obviously, this is a problem across a wide range of issues, but it's likely to be particularly severe with complex technical issues such as economic development takings, where it's difficult for citizens to evaluate the project in question, and as a result, difficult for them to punish politicians who approve harmful takings, or for that matter, to reward those who approve takings that turn out well. There's a related problem which exacerbates this situation that Professor Zelinsky already alluded to when he talked about the short-sightedness of local public officials. In the economic literature, we talk about this as the time horizon problem. As I've already noted, with most economic development takings, it will not become clear whether it was actually worth the cost or not for quite a few years, usually at least 5 or 10 years, sometimes much longer than that. By that time, of course, most of the local politicians or bureaucrats who approve the taking may well not be in office any longer and may well not be in a position to suffer any political retaliation from the voters. So even if the voters do, after the fact, figure out that, this taking wasn't such a great idea, the culprits here, at least on the government side, will no longer be around for them to punish at the ballot box. So if you're a rational local public official, as I'm sure Professor Zelinsky is, then on the one side you can say you can get an immediate boost in your political fortunes by transferring property to a politically powerful entity, perhaps a corporation, perhaps a university, as has happened in some cases, or some other entity. You get immediate boost in your political fortunes, and on the other side there's the possibility that if the voters figure out that the taking was not very effective, which is a big if, by the way, if they figure it out, they might punish you at the ballot box 5-10 years later. Most rational public officials, they'll say, I'll take that benefit and I'll be willing to accept this relatively small risk that if it does materialize, it won't materialize for many years to come. And so indeed, that is what you see with many of these kinds of takings. There are several other aspects of economic development takings which further exacerbate this risk of interest group exploitation. I covered them in great detail in my article here. I'll just note a couple more. One is that the terms of these economic development condemnations, they, as a general rule in almost all cases, they don't actually require the new owner of the property to actually produce the economic development that supposedly justified the condemnation in the first place. And so quite often, they don't in fact produce that development, or at least don't produce anywhere near as much as they were initially expected to. The most notorious example of this is the famous 1981 Pole Town taking in Detroit, which up until the Kilo case was probably the most famous eminent domain litigation in American history. In that case, the Michigan Supreme Court approved the condemnation where in the city of Detroit, some 4,000 people and numerous businesses were displaced so that the property could be transferred to General Motors to build a new factory. At the time, it was promised by GM officials and by the mayor of Detroit that over 6,000 new jobs would be created as a result of this. In reality, probably no more than about half that many were created. And as I discussed in much greater detail in an article I wrote in 2004, it is highly likely that far more economic harm was done by the Pole Town takings than benefit when you take into account the destruction of existing businesses, the displacement of thousands of people, and over $250 million in government funds that were spent just on acquiring the land and clearing it out and so forth. The same thing has happened, at least so far, in the Kilo taking itself, where to date over $80 million in public funds has been spent on this project, but so far nothing has been built. It's not at all clear that anything ever will be built. If something is built, it is highly unlikely to produce anything like the revenue that has been lost so far. And that, by the way, that $80 million, that does not factor in the cost created by destroying the pre-existing use. That's just the cost that the government spent on planning, acquiring property, and clearing it out and so forth. So it's not actually a measure of the full economic cost of the Kilo takings. So in addition to not requiring the new owners to actually produce economic benefits, courts in those states that permit economic development takings also take no account of the costs that are imposed. So I already alluded to the costs of buying the property and clearing it, and of course the costs of destroying the existing enterprises and homes that might be on that property. So if you have a situation where the new owners are not actually required to produce the benefits and you take no account of cost, of course you're going to get lots of projects that create more harm than good. So it's not at all surprising that this is the pattern that we observe, especially when you combine that with the fact that I've alluded to that it's very difficult for the voters to monitor the effectiveness of these projects and to determine whether they were worth it or not, even after the fact, much less before the fact. Now, I do have to acknowledge that there are some potential economic rationales for these sorts of condemnations. And the standard one that is offered is the so-called assembly problem. So if, for instance, let's say I'm a corporation and I want to build a new factory, and I genuinely believe that that new factory will produce $1 million in extra economic gain over and above its cost and above the existing uses of the current property. But in order to build my factory, I have to acquire land that is currently divided up between 100 different owners. The problem that may arise is that as I go about trying to buy up this property, I might go to one of these owners and he says, well, Somin, I'm glad to sell to you. I'm not going to stand in the way of your factory, but I wrote it, you're going to make $1 million extra profit, so you should be willing to pay me $995,000. After all, you'll still end up with $5,000, and that's better than nothing, and you shouldn't mind if I take $995,000. Now, even if I paid that particular individual, of course, the other 99, or at least some of them, will make similar demands, and that will end up sinking the whole project pretty quickly, because if I have to pay each of them $900,000 or whatever, I'm quickly going to end up paying out more money to buy the land than the project is worth. So advocates of these kind of takings say, well, we got to use eminent domain to get these people to sell, because otherwise these sorts of holdouts will sink worthwhile projects. I think there's something to this, but the rationale is greatly overstated. And that's true for two reasons. One that I've already discussed above to some extent is that even if there is some rationale in economic theory for these kinds of condemnations, it doesn't follow that real-world economic development takings will in fact be focused on those cases where there's a genuine assembly problem. As I've suggested, they're in fact more likely to be focused on instances where there's an opportunity to benefit politically powerful people, especially at the expense of people lacking in comparable political influence. But secondly, advocates of economic development takings fail to consider the fact that, in fact, there are good market mechanisms for getting around assembly problems. I've discussed several of them in my Supreme Court Economic Review article, but let me mention just one here, the one that's most commonly used, and that is the method of secret assembly. These types of potential holdouts, they can only hold up a big assembly project if they know that such a project is actually going on. If they don't know, then they're more likely to simply sell for whatever price is above the current valuation that they genuinely place on the property. And so real-world entrepreneurs and enterprises that want to acquire land for an assembly project, what they simply do is they use secret agents, and they don't reveal the fact that there's an assembly project going on, and thereby they're able to acquire the property effectively. This is not just a matter of economic theory. There are many real-world examples where this has happened. One of the best ones is that Disney actually acquired the property to build Disneyland by this method. Harvard University has repeatedly used it successfully to expand its operations in Boston, and there are many similar examples. Obviously, we can't be certain that this will work in every instance. However, if Disney and Harvard can do it, despite the fact that these are very prominent organizations that are closely watched by the press and by other economic actors, then I would suggest that less well-known economic actors can also use secret assembly because the risk of detection is probably smaller than with an entity like Disney. That said, I still would not say that that there are no projects ever where eminent domain could support a project that turns out to be cost justified. What I would argue, however, is that those kinds of projects are likely to be extremely rare and to be greatly outnumbered by the types of economic development takings where there's no economically desirable project going on, but simply a transfer of wealth from the politically weak to the politically powerful with an associated deadweight loss that results from destroying enterprises that might well be more valuable than the new ones that are created. Now, some commentators recognize the problems that I've discussed above, but they say maybe we don't need a categorical ban on economic development takings. Maybe there are other more moderate solutions that can be entertained. I go through a whole list of these in one of my articles. Here, I only have time to discuss the most common one, and that is the idea of increasing the compensation paid to property owners targeted by economic development takings. Some scholars say, well, if you increase the compensation, that reduces the harm suffered by these property owners, and in addition, if you increase the compensation, that may improve the incentives of the government. After all, if they pay more, or if they have to pay more than they do now, then they will have greater incentives to make sure that the project really is worth it, and greater incentives to avoid boondoggles such as the one that Poletown turned out to be. I think there's something to this, and I think there is a rationale in some instances for increasing compensation. However, for two reasons, I think this is actually not likely to be as good a solution as actually banning economic development takings. One reason is very commonly cited in the literature, and that is the problem of subjective value. Under current constitutional law, when government condemns property, they're required to pay the fair market value of the land to the owner. However, in most cases, owners probably value their land more than the fair market value. After all, if they valued it only at the fair market value or less, they probably would have sold it already. And this additional increment of value is known as subjective value. And of course, the difficulty is that it's very hard to design a compensation formula that will actually accurately estimate subjective value because for a variety of reasons, neither owners nor anybody else has a good incentive to reveal that to the government. And therefore, any kind of compensation scheme that tries to compensate subjective value is very likely to either undercompensate or overcompensate. And by the way, I don't think we want overcompensation, because if we did overcompensate systematically, that would actually lead people to lobby to have their property condemned by the government, and that might well be even more inefficient than and harmful than the status quo. The second problem with trying to solve the situation by increasing compensation arises even if you do find the optimal level of compensation, and if you do pay everybody in accordance with their subjective value. And that is quite simply that when government chooses to condemn, the officials who make the decision are not paying for it with their own money. And therefore, if they approve a condemnation project which turns out not to be worth it, it's not like they have to pay for it personally. To the contrary, as I've suggested, they may well end up gaining from it politically by gaining the support of influential interest groups that can take ownership of the new property. So even if we have the optimal compensation structure, it still is likely the government will approve a wide range of economically harmful and undesirable takings, and will only sometimes be deterred from doing so. Indeed, to the extent that it's not just the owners, but also the taxpayers who suffer when these kinds of takings are undertaken, if you increase compensation, you actually increase the harm to the taxpayers, because after all, it's not the mayor of Cleveland or even Professor Zelinsky and his fellow members of local governments that will pay for this. Most of the money will be paid by taxpayers, and so increasing compensation, while sometimes perhaps desirable, does carry the cost of further increasing the burden on taxpayers. Now, as I've suggested, this might be okay if the taxpayers were in a good position to monitor these sorts of takings and punish mistakes by public officials, but I think in most cases, if not all, they're actually in a poor position to do so. So in the very last couple of minutes that I have, I want to talk briefly about efforts to undertake reforms in this area that have happened in the wake of Kilo. As I describe in more detail on in my paper on post-Kilo reform, Kilo has created an unprecedented political backlash, probably greater than any other Supreme Court decision for many decades. Some 42 states have passed reform laws. So has the federal government. In public opinion surveys, 80 to 90% of the public says that they're opposed to economic development takings. Some 60% or more say that they're strongly opposed. So you might think, well, given all this legislation, the problem should have been solved. After all, there's a pretty overwhelming public consensus that cuts across partisan lines, gender lines, racial lines, and so forth. However, as I've gone through the 42 state laws that have been enacted as well as the federal laws, it turns out that the majority of them are actually ineffective. That is, in more than half the cases, while they claim to ban economic development takings, in effect what they really do is allow them to continue under another name. In my paper, I discuss the legal structure of this in more detail than I can here. For now, I'll simply note that the most common means of circumvention is to say, well, you can't take for economic development, but you can take to condemn blighted property. And for most people, when I think of blighted property, I think of horribly dilapidated slums. In reality, however, in most states, including over 20 of the states that have passed post-Kilo reform legislation, the concept of blight is defined so broadly that virtually any property could be declared blighted and therefore condemned. So in practical terms, if you define blight this broadly, any property that might be condemned under an economic development rationale can also be condemned under a blight rationale. One of my favorite examples of this is that just 4 years ago, the Supreme Court of Nevada held that under Nevada law, downtown Las Vegas is blighted, and therefore one could justify the condemnation of some property there to give to politically powerful casinos so they could build some bigger parking lots to serve their customers. Obviously, if downtown Las Vegas is blighted, so too can be your backyard or pretty much any area that local government might seek to condemn. Now you might ask yourself, well, why is this? Why have these laws come out the way that they are? And there are several factors that are at work. I think a crucial one that I focus on in my paper is the very sort of political ignorance that makes economic development takings pernicious in the first place, and that is that most citizens, I think quite understandably, are rationally ignorant about the details of post-Kilo eminent domain law and therefore cannot easily tell a cosmetic reform from one that actually makes a real difference. And indeed, in some survey evidence that I've managed to get commissioned for my article in a national survey, only 21% of American adults know whether or not their state has enacted post-Kilo reform, and only 13% both know the correct answer to that question and can tell whether the reform in their state is likely to be effective or not. And so given that situation, it's not surprising that politicians in many cases can quite rationally choose to either not pass post-Kilo reform at all, as has happened in 8 states, or as has happened in more than 20 states, they do pass reforms, but those reforms don't actually constrain takings in any meaningful way. I don't mean to say that the Kilo backlash has totally failed by any means. As I've discussed in the paper, a number of states have passed strong laws, and in particular, some very strong laws have been passed by the method of referendum. In general, post-Kilo reforms passed by referendum are much stronger and more effective on average than those passed through the legislative process. In my paper, I explain why that distinction actually supports my political ignorance explanation of the overall pattern, but I think I'll save that point for the questions and instead not run over my time any more than I might have already. And I look forward to your comments and questions, and I hope that if you're interested in these issues, you will take the time to read my 2 articles and other papers that I've written on this subject. Thank you.
That's fine. That's fine.
Well, first, I'd like to thank Adam Griffin particularly, and the Law Review, and Dean Simpson and Professor Enton for hosting this symposium. I think I've really enjoyed it. I've got a tremendous amount out of it. I really appreciated this morning's panel. I learned a great deal, and now I think I know why they asked me to talk. Because I think I follow Ilya in the right sequence. I have come at this issue of eminent domain from a different direction. I have not been an academic. I did law clerk for state appellate judge, but have been in the private practice of law ever since that clerkship, and have been practicing effectively complex business litigation, real estate litigation, and eminent domain litigation now for over 30 years, particularly eminent domain litigation. My experience there goes back to the late 70s. Most of my practice in the eminent domain area has been on behalf of property owners, which is why what I'm about to say today is interesting. I have started that process by representing both businesses and residential and land property owners in the Cuyahoga Valley when the federal government came in the late 60s, early 70s, and declared the Cuyahoga Valley National Recreation Area the first urban national park. It sits between Cleveland and Akron. And the federal government effectively eliminated small towns by purchasing fee simple title to property in order to return the property to the green and open space that would create this natural environment. They left some of the towns in place, like Peninsula and others, but some were completely wiped out after the properties were purchased, the land was raised, and it was back to the way it was hundreds of years ago. I was on the side of the property owner. We filed a class action challenging the government's practice of taking fee simple title. We felt that they ought to take scenic easements and let people live there for the remainder of their lives, and even extend that through family ownership until eventually the government could take title. But let people live in these communities that were still naturally beautiful and still had a great deal of open space. That case was unsuccessful under the law that existed then. The Supreme Court did not take the case, and I ended up trying a considerable number of cases in the just compensation phase of the trial. After that, I started to represent property owners in different situations, and I'm going to talk about two of the cases that I handled most recently that are the two largest eminent domain trials that we've had in Ohio, and I think they were very important cases. So I'm going to talk about them at the tail end of my discussion. But let me congratulate Professor Somin on I think an excellent layout of arguments against the use of eminent domain for purposes of economic development. I think those were all the arguments. And I believe that most of them were rejected in the Kelo case. But that is why the issue has life, and Professor Somin's career is being boosted by these opportunities to try to change the result in Kelo. But let me summarize what I heard from Professor Somin, and I think that I'll pick up on this through the prepared remarks that I've got. First of all, he's advocating not honoring what the United States Supreme Court said our Constitution means. The Supreme Court in Kelo is very clear that economic development is a public use, i.e. public purpose, that cannot be intellectually differentiated from any other that the Supreme Court had recognized in past cases. Proposition number one, let's ignore the United States Constitution. Proposition number two, let's rewrite it judicially by saying that you can't take for this public purpose. Third, let's not trust legislative judgments. This goes back to the very beginning of our country when the Fifth Amendment that was written by James Madison, incorporated the eminent domain clause, which recognized the fundamental individual right of property, which needed to be recognized. It wasn't in the colonial period, and it wasn't by the original state constitutions that were enacted after the revolution was successful. But it was eventually built into our Constitution as a fundamental individual right. Good thing. But that clause says that that ownership of private property that's recognized as an individual right is subject to the right of the government to take it for a proper public use and then for just compensation. That is the Constitution. If we rewrite it judicially to say that one public use cannot be afforded through the use of eminent domain, then we have denied what James Madison wrote and what our framers adopted and what was ratified by our country. Next, I hear, as part of that, let's not trust the legislative judgments. They make bad decisions. They come up with bad ideas, and they're short-sighted. That defies every Supreme Court decision that we've had that has built upon the one before it that says this is all about deference to legislative determinations. The courts are not going to make those decisions of public policy. They're not going to make those decisions as to what's in the best interest of the community. That's what legislatures do. And our role is very narrowly carved and crafted as a court, and I'm going to talk about that in a little bit. So if we adopt that reasoning, then we effectively deny the meaning of those Supreme Court cases that say just what I've said. And lastly, this is the one that's the most difficult for me to swallow, don't trust the voters. Don't trust the citizens who have the power of the vote. You could take that one to its logical extreme, and we could talk about how many people know who the president is. Yet we have presidential elections. How many people know who our state legislators are? We have those elections. How many people really understand ballot initiatives? But we have those, and they're very important. I don't think that those are any of those are good reasons to reverse course here. But let me talk about what I came prepared to talk about today. But I needed to get that out at the outset. Sorry. First off, and this is going to be built into what I and one of my colleagues will write and we will put into the law review. So today I'm just going to try to hit some highlights and some ideas and some issues and really write about them and come out with some recommendations and conclusions in the piece that we will submit. But I start out from my basic involvement on the law practice side, the client side, the community side. I've served for 8 years as an elected member of the Shaker Heights Board of Education, so I went through the elective process. I dealt with these issues of tax base and revenues to deal with the achievement gap and to deal with, the needs of a diverse school district. I served as president of the Bar Association. We dealt with regional economic initiatives. I've worked with two mayors, actually three, Mayor White, Mayor Campbell, and Mayor Jackson on these issues. I'm a firm believer that they are the key, they being economic development strategies, are the key to regions like Northeast Ohio, particularly to core cities like the city of Cleveland. If we don't have a well-thought-out, effective strategy as a city, as a region, as a county, we are going to all be in big trouble. Our kids are not going to come back here, they're not going to want to be here, and we're not going to want to be here. And those people who would like to be employed, those people who would like to enjoy a quality of life are going to have a lot of difficulty finding it. And yet look at the assets that we have here. And I'm not going to try to catalog them here. This area has incredible assets. We are sitting on top of a jewel as a community, both culturally, arts, sports, the base of corporate life that we have. There's a tremendous amount here. But we are at risk. And I don't think there's anybody that really understands this today that will not say that this area, this city, this region is significantly at risk if we don't do something meaningful. Now, that's my proposition, that for us to be successful as a community, and I've defined that broadly, we have to have successful strategies to maintain and build a corporate base. And I kind of hearken to the things that were said this morning. Corporations are about building value. And some of that value does inure to the benefit of communities in a meaningful way. And I think that's an important point. The legal issues, the policy issues that come out of Kelo and the Ohio Supreme Court's follow-up case in Norwood present a lot of challenges here. in the use of eminent domain to achieve these objectives, and I'm going to talk about a little of that, and then I'm going to talk about two recent cases that I was involved in this area. For us to be successful, we have to function as a region. I'm not going to get into regionalism, but there has to be thinking beyond the narrow confines of individual political jurisdictions. The tools to achieve those public purposes include eminent domain. They include the incentives that are used rationally and meaningfully that we talked about earlier. But these raise significant legal and policy issues. These issues, and this is my suggestion here, these issues are going to require community engagement. When I talk about the community, now I'm not talking about just the governments. I'm talking about owners of property. I'm talking about community organizations. I am talking about governmental entities. I am talking about the corporate community. And there needs to be real collaboration, a consensus built around common goals and objectives. And I define all of those, and I've not mentioned them all, as stakeholders. We have the religious community that's important. We have minority representation that's critical in this area. All of those groups are stakeholders, in my view, that need to be at the table and part of this process. But we have some problems. Government. We have fragmented government here. I'm going to talk about Northeast Ohio. We've got almost 100 different cities in Cuyahoga County, little cities, 100 of them. Each of them has a fire department, a police department, sanitation. They do all that stuff that they do. This is not conducive to effectiveness. We have a county government that overarches that. City of Cleveland has over 20 wards, 20-some councilmen, a mayor. The county government has 3 legislators that are elected at large. We don't have an elected CEO. Pretty dysfunctional, yet we're able to get some things done despite that. So the challenge here is for intergovernmental collaboration and cooperation with stakeholders to engage in planning. And that's a problematic situation today as things exist. But that is where I'm going with this. We have corporations, we have foundations that are very significant in this community that have leadership challenges because, again, they've got to get on the same page in terms of their priorities. And the use of eminent domain for proper public purposes is a tool that's been a flashpoint around here. And we're going to talk about that. I think that the key here, the key to success for the regional strategy that I talked about to achieve viability is the notion of comprehensive planning. And I mean that in a very generic way. But in order for us to deal with the issues and the problems that we have to pull all of those fragmented governments together, all of those stakeholders into the room, all of the players, to start talking in a meaningful way about what can be done. It's starting here, but we're in the very early stages. There are a couple of things that corporations really need to feel invited and to feel like they want to be staying in your community, they want to expand in your community, or they want to relocate. One of them is the infrastructure that you have. And I'm going to talk about one big example of that in the eminent domain case that I handled 6 years ago. Infrastructure. What are the basic things you have? Transportation, workforce, school systems, housing, cost of living. Those are all considered, infrastructure. And seeing economic development, redevelopment in a contextual way, just not on a corner with somebody putting up a condo or in another area putting up a strip center, but meaningful planning that shows a broader level of redevelopment within which corporations feel that there's an opportunity to expand and to grow and to want to plant their feet and invest. There's a need for eminent domain for these strategic redevelopment concepts. Now, in Kilo and Norwood, we really found some serious questions that were being raised about the use of eminent domain for economic development to achieve this objective. Kilo is a 5-4 decision. I'm not unmindful of that. I've read and reread Justice O'Connor's dissent, especially since she wrote the majority opinion in the Hawaii Housing Authority case some years earlier, and she moved from one place to the other, and that was, I think, a notable movement in her view. But the legal opportunities of Kilo are pretty clear, and this again was decided under the United States Constitution, Fifth Amendment. And it held that the use of eminent domain solely for economic development purposes satisfies the public use requirement of the Fifth Amendment But it commented on a number of things. I've mentioned two here. One, they commented on the entire integrated plan that resulted from a comprehensive planning process. And that's a significant, I think, a very significant point that we need to learn a lesson from as a community. And secondly, that the plan was not adopted to benefit a particular class of identifiable individuals. And that was despite the fact that everybody clearly understood that the means to this redevelopment would be private ownership, that there would be developers that would be brought in and engaged to execute that plan. That would be private ownership. But the court said that just because property is being transferred from one private owner A to another private owner, redeveloper B, doesn't mean that that's the end of the analysis. That's focusing just on how the transfer occurred, not the fact that that was the means, being the transfer, to a larger end which was recognized as a public use. That's the important finding in Kelo that I think needs to be taken away and brought into our planning process. But as I said, community government and corporate and private collaboration is going to be critical. There's a need for intergovernmental, private-public partnerships, and I use the word private partnerships, not representing business interests, but representing community interests, to be forged in order to start championing, and I mean that in the literal sense, leading in favor of cutting-edge planned economic development projects for which it's possible that eminent domain might need to be used. We need some leadership. If everybody gets scared off by the notion of losing an election or losing favor or not wanting to rock the boat, then we're all going to lose. And if this is what our Constitution means, and these are legitimate public purposes, then we have to be willing to use the tools that are there in the Constitution to achieve the objectives. We either use them or we don't use them. And until the law is changed, I suggest the strategy is to use them, but to use them wisely. And I think there's a need for governmental reform. It's a whole other discussion for a whole other day, but we've got to deal with this fragmentation. We've got to deal with the lack of somebody actually being in charge and accountable, in our case in the county government, for what goes on in the county. We need to look at how our government's organized so that when we talk about public-private partnerships, the public part is functional and has leaders that are willing to step up and lead. Now, the legal barriers of Norwood. Let me just talk about Norwood for a minute. This is the Ohio Supreme Court case that many of you know about that followed about a year later after Kelo. And the Norwood Ohio Supreme Court decision dealing with the city of Norwood's redevelopment efforts accepted the Supreme Court's invitation for states, state courts, and state legislatures to go their own way. They specifically invited that in the Kelo decision, that may not be the way your state wants to act. And the Ohio Supreme Court, in deciding Norwood, said, in Ohio, under our Ohio Constitution, Article 1, Section 19, if you're taking property, private property, solely for economic development, this is not recognized as a public use under the Ohio Constitution, notwithstanding the Kelo decision. Now, the court did say that economic benefits may be considered if those benefits are in conjunction with another valid accepted public use. So when you couple economic development with another public use, I think that's another case. And we shall see, because I'm sure that will be challenged as well, and I will show you an example of one that I handled that unfortunately, for me as a litigant, or as a lawyer for a litigant, didn't go up to the Supreme Court because I would have liked to have argued that one. This one was settled, but that issue was raised. The legislative assault afterwards that Professor Somin mentioned, this is occurring all over the United States. There are legislatures that are considering cutting back Kelo, abandoning it, limiting it, providing other mechanisms. They're all over the map, and I think that this will play out over the next number of years. Political and policy constraints. Let me just talk about a few of those. There's tremendous political pressure today for the reasons that you heard on government to refrain from using eminent domain. They're afraid to do it because of the political ramifications. Polls in Ohio show an overwhelming number of individuals are against the notion of using the power of eminent domain to take private residential properties for public use. That's a lot of people. That's a lot of voters. And so there's a political reluctance. And that's a real problem. Political environment impact on costs. What I mean here is that that viewpoint does affect what it costs today to acquire property from, the term holdouts, those people that are really against selling at all or don't want to sell unless it's at an unreasonably, in terms of fair market value, high price. That gets to the issue of, do we change the law to provide a higher level of compensation in these kinds of takings? I think there are a lot of folks that are open to it. I could intellectually understand that perhaps individuals ought to gain a little bit of the uptick in the value that comes from economic development. I mean, from a policy standpoint, I don't have a problem with that. But nevertheless, because of the number of people in Ohio that are so against the use of eminent domain for this kind of purpose, those are the folks that are going to sit on these juries that are going to decide compensation. And believe me, they are going to make the taker pay through the nose, regardless of what the government's appraisals are going to say. So there's going to be a higher premium that is paid for property taken for these projects simply because of that political reality. That's a cost. Incentives, that's a cost, even if they're not necessary. They have to be offered in order to in some ways offset some of those higher costs due to acquisition of property. And intergovernmental competition. Governments fighting with each other to get that company to relocate in their jurisdiction. And that's why I went to the idea of collaboration. Mayor Jackson in Cleveland here has really forged with, I think, the same level of cooperation of a number of suburban mayors, a number of developments now where the Browns practice facility, for instance, went into one community, but several communities agreed to share that revenue voluntarily. Rather than have a winner take it all and everybody else not get it, they agreed to share. And that's actually happened in a number of other cases, and I think that's going to be a pattern that, for good reason, is going to be followed around here. But that competition has a cost. All right, here are the two cases, and I'm going to try to get through these relatively quickly. But you could see all the issues that they raised very quickly. And these are two that I tried. I represented the city of Cleveland, which was defending its ownership of the IX property that it acquired voluntarily from the owner of the IX property. I'm going to talk about what that meant to the airport's expansion. By the way, that should be 2001, not 2008. And just this past spring, we tried for 5 weeks and then settled at the end of 5 weeks the acquisition of all the remaining property for the Flats East Bank project here in Cleveland, and I'm going to talk about that. Hopkins International Airport. The airport for Northeast Ohio, and I would suggest that this is true in most other major metropolitan areas, is the major engine of economic growth. Companies want to know how easy it's going to be for them to get their folks from that location to the Far East, to Europe, or to anywhere in the United States. That reach is critical to those corporations. There's a lot of economic development and economic value that follows an airport system. In Northeast Ohio, on an annual basis, billions of dollars are attributed to revenues that result from our airport operation. So, with that as the background, the mission of the Cleveland Hopkins International Airport, and this, I think, apropos of today, as you can see right in the middle, is to provide nonstop service to international destinations and establish the region as a more desirable location of industries worldwide. This mission's been around for quite a while. So it's right on point. And this is the major infrastructure that I was referring to earlier when I talked about the need to have a solid infrastructure for corporations. Hopkins Airport is a public utility under the state law. And as a public utility, Hopkins Airport was able to acquire property just like electric companies can outside of their jurisdiction in order to function as a utility. That was an important point in this case. Hopkins Airport had been planning for over 10 years, starting with Mayor White, to expand our runway system. We needed additional land ultimately to have 2 parallel runways, one to service our domestic traffic and one ultimately for a long-term extension that would provide the capacity for the international flights. And we needed to distance those 2 runways in order to accommodate automatic instrument landing, which we don't have today. And we have to do all this either one runway at a time or manual landings, but we can't do them instrument-wise in bad weather, which is why you need them, and we got plenty of that. So, that's not an ad for Cleveland. But that was critical, to have that separation that's necessary and prescribed by the FAA, to have two simultaneous landing and takeoff runways, which is what you need in order to accommodate a significant increase in air traffic demand. The FAA was in favor of this. Airport planners supported it. All the statistics showed that over time the demand was going to be there to support, economically support, the viability of those two runways. The short-term plan to extend one runway was in the 10-year time frame. Our case was about proving that in about 15 to 30 years, we were going to need this additional land to build that second parallel simultaneous operation runway. In other words, we don't need it today, we need it in 15 years, and that's why we want to get the property today. And that was our burden of proof in that case. We were able to show the court in that trial that the present and future uses of the IX property, which is the 100 and some acres of land that was needed to do this, was going to be used in the future. And we had to establish a reasonable assurance of future use. And we did that through economists, we did that through airport planners, we did that through you name it, we had that evidence in the case. So in order to do this, Cleveland did not use the power of eminent domain. As a public utility, it could have done it. But Mayor White was ultimately, over the years, successful in negotiating a deal to purchase the IX property from the private owner that operates this as an exposition center for trade shows, and to then lease it back to the owner for 15 years, let the owner continue to use it as a trade show facility, with the agreement that if the airport needed it sooner than 15 years, it could terminate the lease, effectively take the lease by eminent domain, and would pay certain compensation under the agreement that was negotiated. That was the deal. Struck fair and square. Cleveland had the land it needed to do this, did not have to use eminent domain. On the day the deed was being filed, the city of Brook Park, in which this land sat, this was not in Cleveland's jurisdiction, it was just across the jurisdiction, contiguous to the airport in Brook Park filed an eminent domain action to take all of the IX property for its own economic development plan, which it had. It actually had an economic development plan to use all that land for shops and retail and hotel and motel and other stuff that was going to boost Brook Park's tax base. Now, this is before Kilo, this is before Norwood. Ironically, the city of Cleveland argued that under the Ohio Constitution they couldn't do this solely for economic development. That was Cleveland's position. The court rejected that. Summary judgment was denied, and we moved on with the case. But that action was filed. That case proceeded to trial. And during the trial, and this is the story, this is part of the story here of what can happen when the stakeholders pull together. And the stakeholders pull together around the need for this airport. We showed, and we showed this in the trial, but this is really what made this happen, that there were significant forces, influences, pressures, and facts, all of which showed that this community was going to support the use of that property for airport expansion. We had all the political leadership that you could imagine stand up and say it. We had the business and other community representatives stand up. The Greater Cleveland Growth Association had done a study on air traffic on behalf of the corporate community that demonstrated the need for this, all the points that I made earlier. Cleveland Tomorrow, which is an association of the, I think at the time it was the top 50 corporations, the CEO of every one of those corporations is on that group. They supported this. Continental Airlines is the hub carrier here, and I had Gordon Bethune on the witness stand. And Gordon Bethune said, it's not a question of if we need it, it's a question of when. He supported the FAA study and said that if this land was not acquired, Continental was leaving Cleveland because they couldn't afford to have a hub that couldn't grow. And by the way, if Cleveland didn't get this land, there was no other land that Cleveland was going to be able to get to support expansion. Cleveland would have been landlocked as is, and that would have been the demise to the airport, which, by the way, was our damage to the residue argument. And we had a $5 billion damage case that we never had to present, which is what the damage to the rest of that airport property would have been if we had to have our property that we acquired at the IX taken. That was a pretty formidable damage case we never got to present. The political pressure that I've just described in favor of this expansion made this use inevitable, and the court accepted that. The court accepted all the planning, all the FAA support, all the hub carrier support, and all the community support as collective evidence that there was a reasonable assurance of future use. And that case was won on that basis, that we had established a valid public purpose, public use, by showing the reasonable assurance of that future use. That's a case of two public entities fighting over the property for their own public uses, and that's what I'm talking about when I talk about intergovernmental conflict. That can happen again. It could easily happen again. I want it for a road, I want it for a shopping center. I need the roadway expansion for some utility purpose. I mean, I could see it. And so this is where we need to pull together as a community, and I think that the seeds are there for us to do that. The second case, and I'm going to get through this a lot faster, was the Flats East Bank. This was a historically successful area that had the fragmented ownership that Professor Somin talked about. And the fragmentation of that ownership led ultimately to such divergent uses that you had family restaurants next to bars that were serving underage drinkers. And eventually the family restaurants and the other family businesses collapsed. Businesses went out of business left and right, and that area became blighted. And it was declared blighted by the city of Cleveland under the city's blight ordinances that had been around for 25 years. Economically distressed, you could imagine, by virtue of all of the board-ups. Cleveland adopted a community redevelopment plan, did a blight study, determined that a significant portion of the redevelopment area was blighted. But this was done after the city of Cleveland had done a waterfront district planning process, which included participation by the state of Ohio, by a regional transit authority, by the city of Cleveland, by the Cleveland-Cuyahoga County Port Authority, which is basically an economic redevelopment engine that does a lot besides be responsible for our port. A lot of community organizations, a lot of corporations were all working together as a consortium on what are we going to do with our waterfront? How are we going to maximize its value, redevelop it in a global sense? And I'm talking about a 10-mile stretch of waterfront. All of the different uses you could imagine, extending up the Cuyahoga River, and they planned it by different areas, determining exactly how they would be used. Within that waterfront district plan sat the Flats East Bank. The Port Authority and a redeveloper entered into an acquisition agreement that provided that the port would use eminent domain to acquire land that could not be acquired through negotiation, would reconvey it to the developer that was obligated to develop it in accordance with the plan, which was a development agreement. The development agreement was an agreement among the city of Cleveland, the Port Authority, and the redeveloper that laid out every public use, every public purpose that the port had in enacting its legislation to take, and the city of Cleveland wanted in order to accomplish the community development plan. Those public purposes included housing, 400 units, transportation, parks, government operations. They were going to completely raise the area, and are going to completely raise the area, redo all the street grids so that they line up to sight lines to the river, and put utilities in, sewers in. Right now, we have a unitary sewer system there, meaning water that collects from rain and sewage flow through one pipe into the Cuyahoga River. That's the system that's down there now. This project allowed a modern sewer system to be put in that would eliminate that pollution. One of the reasons the federal government supported this. The project that I've described provides public access to the riverfront through a pedestrian promenade, a marina, new street grids, as I've described, the waterfront housing units, mixed retail, a couple of thousand jobs, $3 to $4 million annually for the school systems in the city, $500 million to $1 billion of increased economic activity. This is all an economic study that was done to support it. This was the unprecedented part of this. This wasn't just supported by the city and the Port Authority. The federal government was in there with $6 million of grant money, largely for the riverfront stuff. The state came in. This is all brownfields, by the way, and it's all being cleaned up. The city of Cleveland loaned money and provided TIF financing and everybody knows what TIF financing is. It was a win-win. It was going to be a win-win. Cleveland Development Advisors, an arm of our growth association, put up loan money. And by the way, all these loans the redeveloper's obligated to repay. Cleveland Public Power putting in utilities, Division of Water putting in utilities. The eminent domain action was hotly contested. There were 12 parcels that were owned. These are all commercial properties. Larry Flint's Hustler Club was there. So we had the Fifth Amendment wrapped around the First Amendment in the case. And it was tried for 5 weeks. Every challenge to every constitutional provision was made. The court granted summary judgment in favor of the port on all of them. We tried the case for 5 weeks, their case. We never got to our case. And we were ultimately able to acquire at premiums all the property at the end of that 5 weeks. Those issues that were joined in that case challenged every conceivable thing that you could imagine being challenged under Kelo and under Norwood, and would have been a fascinating appeal if it had ever proceeded that far. So in conclusion, I argue to treat our Constitution as just that, a living document. I believe Kelo got it right. I just think it has to be respected. I think that we're going to have issues in the future about the standard of review, how scrutinized should these plans be, and I'm willing to consider a heightened level of scrutiny in certain respects. Exactly what's afoot, I think Kelo made clear that we've got to look at the facts very closely, and there might be a set of facts presented that would drive in a different direction. But ultimately, our survival and our success depends upon harmonizing the community's interests that I've described with those interests of private property owners so that we can have a win-win. Ultimately, if an owner has to give up a property for a public use, that's what our Constitution provides, and I keep coming back to that. So there's a lot of uncertainty. There's a long way to go. We're going to be having these debates for a long period of time. I suggest you fasten your seatbelts, but I don't think there's anything more important than reconciling the needs of our community with those of the rights of the people that live in it. Thank you very much.
I'm told we have just a couple minutes for questions, if there are folks that have questions in the audience. Professor Denning.
This was a comment to something that Morgan said. You were wondering why all the Dormant Commerce Clause challenges are dropping out. I offer this up as a possible explanation. Maybe Ed has some thoughts on this as well. My sense is that Peter's argument, the way that Peter characterizes discrimination as anything that potentially, quote unquote, distorts economic choices or renders, or influences choice in terms of locating or relocating. I think if taken to its logical conclusion, as I think Ed has suggested, it means that a lowering of the marginal tax rates for corporations in State A could be challenged because it distorts decision making among existing businesses about whether to relocate to a lower tax rate state. I mean, everything would become discrimination, at least potentially. And I think that's too broad, and I think courts were going to reject it. The other thing, I think the U.S. Supreme Court is probably doing more in the Dormant Commerce Clause area right now than it has in the previous 20 years, I would say. And one of the things that I see it doing is actually shrinking the realm of what can be considered discriminatory. And I think that's going to continue to shrink as you get pressure from people like Justice Scalia and Justice Thomas who want to do away with it. And it appears that Chief Justice Roberts is going to follow Chief Justice Rehnquist's position that it ought to be narrowly confined if enforced at all. So I just offer that as a possible explanation.
Yeah, I think that's a great explanation, and it might give a little more credit to the plaintiffs' attorneys than I was going to give to them, which is just, as a practical litigation strategy, we don't want to have to mess with it. That could be what it's doing. It was clear to me from reading the North Carolina appellate court case that the North Carolina Court of Appeals didn't want to mess with the Dormant Commerce Clause right now. And they clearly punted on that one. And that might be because they're sensing some action and they don't want to, they don't want to go where they don't have to go. That's a good point. Did you want to?
Just as a note, I teach the Dormant Commerce Clause in con law. I don't want to mess with it either. It's incomprehensible, even for those of us who make our living in part by trying to understand it. My comment goes to Ilya. One one point you made toward the end of your talk. You said 21%, only 21% of the population knows whether their state has passed kilo legislation after kilo. And that struck me as a huge number. I don't know whether Massachusetts has passed that. We live in a country where 5% of the American people think Joan of Arc was Noah's wife. 60% of the American people think the Earth was created 6,000 years ago. So to think that 21% of the Americans know about kilo, even have any inkling of kilo, strikes me as a huge number. So how would it change your thesis if your underlying assumption switches from rational ignorance to mind-blowing awareness?
I would say several things. One is the 21% is very likely an overestimate because you could get the question right by guessing, and many people do guess on public opinion surveys rather than admit their ignorance. So the 21% is an upper bound on a number of people who know. The true number, it's hard to know for sure, but I bet the true number is like 12, 15%, something like that. Also, knowing that your state has passed post-Q legislation is not very useful unless you also know whether that legislation is effective or not, and that is only known by an upper bound of 13%, which again there, the guessing was a little harder because you'd have to guess right on 2 questions rather than 1, but you still have about a 25% chance of getting that right by random guessing. Lastly, I don't think 21% is a high number for mere awareness that an issue exists. There are lots of other issues where mere awareness that legislation exists or an issue exists would be much higher than 21%. It is true that far more than 21% know about the Kilo decision itself. But that's my contention in the paper, is that while people know about the Kilo decision and know, most of them at least, that they want to ban economic development takings, they lack the additional knowledge that is necessary to make this judgment effective. Now, are there other issues where knowledge is even lower than that? Yes, there certainly are. I would argue that political ignorance will be an even more serious problem with respect to those other issues, but that doesn't mean it isn't a problem in this area.
You have time, I think, for one more.
I guess one other very small point on this, and that is that I plead guilty to the charge made by opposing counsel of being suspicious of legislators and voters. I will only say that it's precisely because we are suspicious of legislators and voters that we have a Constitution, a Bill of Rights in the first place, and in many areas where particularly those where political ignorance is likely to be an especially serious problem, there is good reason for that suspicion and good reason for severely limiting the power of government to be involved in those matters.
I'll take the moderator's prerogative just to ask a final question that to anyone who wishes to address it. I'm wondering if in this discussion we're dealing with a problem of the seen versus the unseen and thinking about what is it that allows for communities to be economically vibrant and growing. And that is when we're talking about tools like tax incentives or eminent domain or any other sort of tools that communities tend to use, we're talking about tools that by their definition can pretty much only be used for the companies that are already there. And so in many respects for the companies and sources of growth of yesterday. But can't be used or are very difficult to use for the companies of tomorrow. That is the startups, the Dells or the Googles of tomorrow, the entities that at least many economists would argue are the actual source of organic bottom-up economic growth. And if that is the case, is there any way to get out of that trap? Because obviously political institutions and legal institutions have a much easier time dealing with the things that are already there rather than speculating about what may come in the future. And is there any way to think about, in terms of communities and their relationship to corporations, how they can play a greater role in encouraging the corporations of tomorrow that can't be at the negotiating table, that can't be involved in litigation, that can't be lobbying for the precise reason that they're, someone's idea in a garage somewhere?
Well, just a real quick answer. I think that that one of the things that we do is think about talent attraction, because those startups, particularly the kinds that you're talking about, require well-educated talent to want to largely come to Cleveland. And I think that by creating the infrastructure, by creating the housing opportunity, the affordability of it, the location of it, and the other things that a community can offer through developing itself or redeveloping itself and improving its tax base, does that. And I think the long-term goals of the Great Cleveland Partnership now are built around talent attraction, and I think that goes to your point.
Yeah, just very quickly, I think this is a part of what I was talking about, the seen and the unseen, that when you promote an economic development takings project, you say, well, we're going to build a great new factory, as GM said they would in Detroit, and what you don't necessarily see is the economic development and other beneficial uses that would have existed on that property had eminent domain not been resorted to and the owner's been allowed to continue with their plans. And you certainly don't see the businesses that might have come in 3, 5, 10 years later to come in and possibly use those properties. And certainly those businesses cannot be a part of the planning process that Mr. Kaufman referred to in his presentation. So it seemed to me that there is a strong bias in favor of status quo, powerful interests. Those are ones that can effectively lobby for property to be transferred to them through the economic development takings process. And it was said, well, maybe if politicians weren't afraid of losing elections or were more willing to be real leaders, we could prevent some of these problems. But I think that the kind of politician who's not afraid of losing elections is not likely to be in office for very long, and that therefore the long-term incentives of political leaders in this field will be, in fact, to benefit the politically powerful, because those are people who can keep them in office. How do we break out of the trap? I think what we want to do is ban economic development takings and leave the determination of these sorts of property uses to market competition and other sorts of private ordering. I agree with Professor Zelinsky when he suggests that the way for communities to engage in more effective and beneficial competition with each other is through generalized tax incentives and to building a generally good climate for economic development, rather than to be in the business of offering specialized favors to particular powerful interest groups.
Other thoughts?
I agree with Professor Zelinsky also.
Well, great. Well, please join me in thanking our panel. I believe we are